Good afternoon. This is Jean Hemphill, Ballard Spahr. We appreciate your attending our seminar today on HIPAA and the final rules. I'm joined today by several members of our HIPAA team. Ed Leeds from the Employee Benefits and Executive Compensation Group has been involved in the group since when HIPAA was passed in 1996, and has been a lecturer on this subject many times. We also have two new members of our group who are presenting today. Amy Mushwar recently joined Ballard's and is a national expert on privacy and security matters, particularly security and data protection, and she's in our Washington, D.C. office. Dee Spagnola is in the Philadelphia office and is part of the White Collar and Investigations Group, and works with Beth Moskal-Schnall and others in investigations, enforcement, and audits, and other litigation-related matters. So we're pleased to have their input here today. We are going to cover today the final rules that were issued by HHS on January 25th, 2013, relating to refinements of the HIPAA regulations, final regulations on various HITECH matters, and the Genetic Information and Non-Discrimination Act, or GINA law, is also covered by the final rules. Compliance begins September 23rd, 2013, although there are a few transition dates and exceptions to that compliance date that we will discuss. During the next hour and a half, we're going to discuss the new standards that are applicable to business associates. That's a large part of these regulations. Also importantly, the new breach definition and related notification developments. There are also stronger limitations on the use and disclosure of PHI for various activities such as marketing and fundraising that we will review. The GINA amendments to the HIPAA rules. The various expanded individual rights relating to particularly electronic health records, and the enhancement of the enforcement rule, increased audits, civil monetary penalties, etc. We hope to have some time at the end for questions, but we're never sure. But if you have questions, we certainly will take them independently if we cannot take them here. So I'm going to turn to Ed Leeds at this point to give us a quick overview of HIPAA's origins.
Thank you, Jean. Before we begin our discussion of the recent developments under HIPAA's privacy and security rules, we did think that it would be useful to set them in context by providing at least a very quick refresher on the HIPAA rules as they applied before the recent regulations and even before the HITECH Act. If you had to encapsulate the HIPAA privacy rule in a simple sentence, it might read something like this. A covered entity may use or disclose protected health information only as HIPAA expressly requires or permits that use or disclosure. If HIPAA doesn't say that you can do it, then you can't do it. The security rule is both narrower and broader than the privacy rule. It's narrower in the sense that it applies only to information that's held or transmitted through electronic media. But it's broader in that it applies not only to keeping information confidential, but to keeping it accessible to those who need to be able to see it, and to maintaining its integrity, which means safeguarding it from inappropriate alteration or other changes. These simple sentences really require us to define terms, so I'd like to start by defining the type of information that's subject to these rules, and that would be protected health information, or PHI. PHI is information in any form. It could be written on a piece of paper, it could be set forth in an email, it could be whispered in an elevator. It doesn't matter what form it takes as long as it meets three criteria. First, it has to be handled by a healthcare provider, health plan, employer, or healthcare clearinghouse. Now, to understand what a healthcare clearinghouse is, it's worth knowing that there are some very closely related provisions in HIPAA that establish standards for the electronic transmission of health information in certain transactions. A healthcare clearinghouse is essentially an entity that translates data to or from that standard format. Okay, the second criteria is that information has to relate to the medical condition of an individual, care for that condition, or payment for that care. And the third requirement is that the information has to be individually identifiable. Now, that doesn't necessarily mean that the information has the actual name of the individual. It could have other identifiers like a social security number or a telephone number, or even just a piece of the individual's address, or a birth date, or the date that the individual was admitted to the hospital. If these identifiers individually or taken together render the information susceptible to identification with a particular individual, it will be regarded as protected health information. So that's what is subject to HIPAA. Now the question is, who is subject to HIPAA? And that would be a covered entity. And there are only 3 types of covered entities under HIPAA. There are health plans, and that includes group health plans sponsored by employers, but also health insurers, HMOs, various government-sponsored benefit plans are all considered health plans. Second, there are healthcare providers who engage in one of those electronic transactions for which HIPAA has set standards, which I mentioned earlier. That isn't every healthcare provider, but it's certainly the vast majority. And finally, healthcare clearinghouses, which I described earlier. That's it. Those are the only covered entities. So who's left out of the equation? Well, actually, there are a number of things left out of the equation. But for our purposes, the most important thing that it leaves out would be vendors of covered entities, who often have a lot of protected health information. When a vendor of a covered entity obtains that protected health information, it's not considered to be a covered entity itself. It goes by what HIPAA calls a business associate. Under the original HIPAA rules, business associates had no direct responsibilities under HIPAA. However, covered entities were required to enter into contracts with these business associates. We would typically call these business associate agreements, and that would require them to meet some but not all of the privacy and security rules that apply to covered entities. If a business associate failed to meet its obligations, then the covered entity might be directly liable for penalties imposed by the government, but the covered entity could then turn around and try to recover from the business associate for violating the terms of its contract. So we've described we've said that covered entities can use protected health information only as HIPAA requires or permits. So how does HIPAA require the use or disclosure of protected health information? There are really only 2 occasions. First, individuals have certain rights with regard to their own protected health information. For example, an individual has the right to see certain of his or her own protected health information on request. If an individual chooses to exercise these individual rights, then a covered entity has to use or disclose protected health information to meet that request. That's a required disclosure. Second, the Department of Health and Human Services may request protected health information as part of an audit or investigation into the covered entity's HIPAA compliance. The covered entity has to comply with that request. That's another required use or disclosure. There's a broader range of uses and disclosures that's permitted under HIPAA. The first set of activities listed on this slide, treatment, payment, and healthcare operations, covers just about all of the activities that a covered entity would undertake on a daily basis. There's a list in the HIPAA regulations of other less common reasons for handling protected health information that would also be permitted. And I've listed some of them here. For instance, you can use or disclose protected health information to comply with other legal requirements, or for certain public health activities or law enforcement activities, or judicial proceedings. If you get subpoenaed, that would be a permissible use, or research. And there are others. And there are rules and procedures that you may need to follow in using or disclosing information for these purposes. But if you follow those rules, then these are permitted reasons to use or disclose protected health information. If you don't have one of these permitted uses or disclosures or one of the required activities, then you either have to obtain the individual's authorization for the use or disclosure, or you have to strip that information of its identifying characteristics and render it what they would call de-identified so that it's no longer protected health information. Now, there are, in addition to saying when covered entities can use or disclose protected health information, the HIPAA privacy and security regulations include rules on how covered entities have to handle the information. And there are a number of requirements. Covered entities have to establish physical safeguards like a locked file cabinet. They have to establish technical safeguards like password controls and administrative safeguards. These are rules that the people who handle protected health information have to follow. These administrative safeguards include a requirement that's particularly important called the minimum necessary rule, where covered entities have to make a reasonable effort to use the minimum amount of protected health information necessary to accomplish an appropriate purpose. Now, covered entities also have to designate individuals to serve as privacy and security officials. They're responsible for implementing the covered entity's HIPAA compliance program. And they have to designate an individual or an office to receive and respond to complaints about privacy or security. They have to train members of their workforce, those who handle protected health information. They have to train them in their policies and procedures. And they have to document their efforts to prepare their HIPAA compliance effort and to have a number of HIPAA compliant forms. And these include setting forth their internal policies and procedures for both privacy and security, distributing to individuals a notice of privacy practices. They have to enter into business associate agreements with their vendors, and they may need to have HIPAA compliant authorization forms. And if you're a health plan, you may need to amend your health plan document. There are ongoing responsibilities, particularly with regard to security, where electronic access needs to be monitored and your safeguards need to be updated from time to time in view of the ever-evolving security threats. That brings us to our first set of changes under the new rules, those affecting business associates. I'm going to talk about three types of changes that affect the requirements. There are changes to the definition of business associate, changes to the rules affecting business associate agreements, and the imposition of direct responsibility on business associates. The new regulations include a number of clarifications to the definition of business associate that tell us who is and who is not a business associate. For example, vendors who obtain protected health information in performing activities relating to patient safety, so-called patient safety organizations, are more expressly included in the definition of business associate than they would have been before. Similarly, vendors that transmit data and that require routine access to protected health information in the course of transmitting that data will be considered business associates. And the regulations specifically identify some of the new kids on the block for this purpose: health information organizations and e-prescribing gateways. They're distinguished from mere conduits of information like the Postal Service and the telecommunication networks. Personal health record providers will be regarded as business associates if they perform their services on behalf of a covered entity. But if they perform their services directly on behalf of individuals, they will not be. And probably the most significant change in the definition of business associate is the addition of subcontractors. When a business associate subcontracts its responsibilities that it is supposed to perform for a covered entity, and the subcontractor obtains or creates protected health information for that purpose, the subcontractor becomes a business associate. If that subcontractor in turn passes on some of those responsibilities to its own subcontractors, they become business associates, and so on down the line. Under the new rules, that means that each business associate has to enter into a business associate agreement with each of these subcontractors. That's a broader and more formal requirement than has applied in the past, and it comes at a time when the rules for business associate agreements are changing. all business associate agreements need to be modified to reflect certain new rules, and I've identified 4 changes in the regulations that have to be accounted for in the business associate agreements. Under the business associate agreement, a business associate has to agree to safeguard protected health information, and not only that, but to comply with all applicable security requirements. The obligations of a business associate to report certain events, like security incidents, now also has to include the reporting of breaches, and we will be discussing breaches in considerably more detail in a few minutes. Business associates also have to agree to pass their obligations under the security rules onto their subcontractors in a written business associate agreement. And finally, and I think most expansively, a business associate has to agree to comply with the HIPAA privacy rules to the extent that it carries out a covered entity's obligations under the privacy rules. Now, there are various other considerations for business associate agreements that business associate agreements have to account for. I can't possibly identify them all, but certainly you're going to want to consider elaborating on some of the responsibilities that a business associate will have. And particularly, I have in mind those breach rules, again, that we will be talking about, and the allocation of responsibility for providing notice of breaches in certain situations. There's another requirement, and for this it makes sense to go back to the HIPAA rules and business associate agreements. If you've seen them, you have probably seen this, that a covered entity has an obligation when it becomes aware of a business associate's material violations of the agreement to take certain actions to correct those violations or get the business associate to correct them. And if it can't do that, then to terminate its relationship with the business associate, and if that's not feasible, to report those violations to the Department of Health and Human Services. The HITECH Act imposes a reciprocal obligation on business associates when they become aware of a covered entity's material violations. I haven't seen in the regulations any kind of requirement that that has to be included in the business associate agreement, but in business associate agreements that I've been working on, I've already seen this provision starting to creep in. So that's something that you may want to keep in mind when you draft your business associate agreements. Incidentally, the obligation to report a business associate's violations to the Department of Health and Human Services has gone away. It's no longer required under the rules. So that's something that you may also consider. There are particular transitional rules for business associate agreements. If the business associate agreement was already in place before January 25th, 2013, and where you don't really modify your arrangement with the business associate, then you could have up to a 1-year delay in the need to produce a new business associate agreement that meets all of the requirements. Finally, I want to talk about how business associates are directly subject to HIPAA, and keep in mind that previously they had only contractual liability. Now they will be directly subject to HIPAA for almost all of the HIPAA security requirements, and certainly under the preamble for the business associate agreements, for uses and disclosures that violate HIPAA and for the HIPAA privacy rule, and for a number of other specific acts. They could be liable and directly responsible for civil or criminal penalties, and they could be subject to enforcement mechanisms directly under HIPAA. And keep in mind that the subcontractors who are business associates could be subject to these sanctions as well. That concludes our examination of the new rules affecting business associates, although some of it will spill over into other discussions. I've held you in abeyance long enough with regard to the rules about breaches, and I'm going to now turn it over to Amy Mushwar, who's going to examine those rules and some broader concerns. Amy?
Thank you very much, Ed, and thank you to everyone who took the time out to listen to us today. I happen to think that we're in a watershed moment in terms of HIPAA and breach reporting. And for those of you on the line, I'm going to be speaking primarily from the posture of a covered entity, so a healthcare provider, a pharmacy, a doctor's office, and those assisting under vendor agreements and business associate agreements, primary covered entities. I know that many of you on the line fall under that category, either the covered entity or the vendor. But for those of you who fall outside that line and perhaps are looking more as your role is as an employer, there are some things that may not be applicable, and we'll try to point out where we're coming from a particular perspective. The old rules defining a breach. Many of you on the line already know the HIPAA HITECH rule. For those of you who are new to HIPAA or have newly fear in HIPAA as a result of this rule, it bears for us to just repeat where we were a few years ago. Under the 2009 rules, an impermissible use or disclosure of unsecured PHI, including electronic PHI, was only a significant breach if it posed a significant risk of financial, reputational, or other harm to a person. This harm standard was rather difficult for us to interpret, and I'll be quite frank because I'm probably one of the problem children in terms of this rule. It led to many of us in the industry deciding not to report certain breaches. If we could find some way that, notwithstanding the fact that information has been disclosed, we could see that there was no potential harm with regard to identity theft or with regard to disclosure or of sensitive PHI without consent. Times, they are a-changing, however. With the new rule, there is now a presumption that an impermissible use or disclosure of PHI is a breach subject to the HIPAA rules, subject to breach notification. We are presuming that information is falling in the hands of bad people, unless there is a low probability that the protected health information has been compromised. We're going to flip to the next slide. What does this mean? How would we demonstrate to HHS what is a low probability of PHI compromise? To be frank, we're now going to perform risk assessments, which is going to include documentation and an analysis during a very critical or time-sensitive time. So, for those of you on the line where you're socializing the new rule requirements, I would socialize the low probability standard and the fact that you're going to have to undertake this risk analysis during the heart of the breach before you actually have one. What will this risk assessment need to include and weigh? It will need to weigh the nature and extent of PHI involved, including the types of identifiers and likelihood of re-identification. Note that because you're not only considering what details have been released, but how could those details be used in combination with other databases and publicly identifiable information to commit identity theft, to identify a person. You have to consider the unauthorized person who used the PHI or to whom that disclosure was made. That prong strikes to the very heart of the affidavit practice that most of us engaged in when we had data breaches. If we released PHI to a third party and we could get them to sign a sworn affidavit that they would not share or use or disclose that information, we tended to find that there was no risk of harm. I think there will be some challenges to that practice in the coming years. And then the next criteria is whether the PHI was actually acquired or viewed. What does this tell me? For those of you on the line who are security professionals, this is log file management. We need to know whether or not there was a database or virtual machine that was accessed. We need the sufficient logs to understand where precisely in the machine architecture there was a breach and there was an access. We need to know if there was an SQL GET request. I know that many of you have sufficient granularity within certain databases, but probably not enterprise-wide. So this is a very good time to go through your log file management and consider centralization of your zone files and your log files. And then the last criteria is the extent to which the risk to PHI has been mitigated, is there anything that you can do as an organization, notwithstanding the release, to limit the likelihood of harm to the consumer, to the patient? Now, in terms of the risk analysis, there are just a few musts. The DHHS is requiring us to address all 4 factors. You can address more, but at a minimum, you must address these 4. You must evaluate the overall probability that the PHI has been compromised. When I mean overall probability, you can't let 1 or 2 factors overwhelm the totality of the factual circumstances. For example, going back to the affidavit point, you might be able to get an affidavit from a third party and get them to disclose that there was that they will not share or otherwise disclose the information that they have received. However, in the totality of the circumstances, you may not know that third party other than through the circumstances of this breach. And what if that third party received Social Security number information, credit card information? In the totality of the circumstances, that might be an instance needing disclosure. And then, without a low probability that PHI has been compromised, breach notification is required. What is the end result of all of this? More breaches will be disclosed. And we've said this, and Ed has said this, and I'm sure Jean has as well. HHS explicitly says in this order that they intend to produce more objective and consistent breach determinations than their old standards did. One thing that we need to keep in mind, we are not looking at HIPAA in isolation. State law is still valid for those of you who are health providers. For those of you who are employers, you will definitely have a preemption analysis. But the current rule for health providers does not preempt most state breach reporting laws, and we know that we have a 48 law structure. The HIPAA rules, there is no conflict and no preemption if a covered entity is able to comply with both federal and state law. So this means the rat race continues for us. Here at Ballard SPAR, we have a proprietary data breach toolkit which helps companies streamline the analysis per federal law and state law. But know that in the heat of the fire, you will have to undertake the HIPAA low probability of harm analysis, and then you will have to undertake the risk analysis as it is interpreted throughout the 48 separate states that have data breach statutes. What does all of this mean at a 5,000-foot view? For those of you who are responsible for compliance and security due diligence within your organizations, this is a way to elevate status and to elevate some serious concerns, one of which is encryption. If, in fact, the PHI released was encrypted, it is not unprotected PHI subject to the breach notification rule. Moreover, under most state laws, there is also not a breach because it is not an unprotected release of personally identifiable information. So as a risk mitigation strategy, encryption is one of the best ways that you can keep yourself out of breach notification. And in addition to HIPAA and state law, for those of you who are public companies, to keep you from reporting breaches on your SEC 10K annual report, as you are required to do if the breach is material to to an investor who would like to invest in your company. So how do we move ourselves from getting very concerned about the new rule to avoiding to really putting ourselves in the best position should we have a breach or data disclosure event? Really what we should be doing is avoiding the breach to begin with. Companies that have effective compliance programs are less likely to experience a breach, and when they do, it's far less expensive. For the CISOs on the line, make legal your best friend, and for the legal and compliance officers, make CISOs and Chief Information Security Officers and IT security your new ally. We understand that these are groups that tend not to talk to one another, and we understand that even those of you with extremely sophisticated data security policies, procedures, and practices are not regularly communicating those practices to legal personnel and C-suite employees, and the HIPAA rule will require this to change. Okay, I'm trying to change over to the next slide, but it is not moving, so if you guys in Philly could please move the slide over. Here at Ballard Spahr, we've already anticipated, just because of the movement within the presidential cybersecurity discussions, movements on the Hill for further legislation, the HIPAA rule, and the extraordinary number of hacks that we have seen in the past several years, and we have dealt with many of the Chinese hack incidences before they were publicly reported in the hysterical way they're being reported now. We have already thought through a client alert helping company IT security personnel and CISOs speak to their legal personnel. I have included a screenshot of this internal security socialization document right here within this presentation, and feel free to contact us for a copy of this. It's one way on just a technical to legal level you can start a dialogue with your CISO or your legal professional. Very quickly, use the new HIPAA rule as a funding mandate. We realize that there are many technical projects that are underway that are woefully underfunded, and use this ruling as an opportunity to elevate log file management and other types of projects that might be sitting on the back burner. With all of that information that we've skimmed over, I'm going to turn it over to Jean Hemphill, who will talk about HIPAA and marketing, and thank you everyone on the line for your time.
Thank you, Amy. This is Jean Hemphill, and we're going to switch now to the parts of the new rule that relate to the use of PHI for fundraising, research, marketing, and the sale of PHI. All of these subjects were covered in the original HIPAA rules. Then there were some refinements in the HIPAA statute, and these final rules both address the HITECH changes, but also make some clarifications to the original HIPAA rules. With respect to fundraising communications, I have noted here on the slide in bold italics the part of the regulation that is new. A covered entity may use or disclose to a business associate or an institutionally related foundation certain PHI for the purpose of fundraising for the benefit of the covered entity. We've had questions in the past as to whether business associates could use the PHI for fundraising for their organization, and the answer is no. This is for a covered entity using it for raising money for their benefit. When we say certain PHI, the regulation originally said demographic information and dates healthcare was provided. There was some FAQs and guidance that led individuals to believe it could go beyond that. Now they have clarified in the regulations that you can have targeted fundraising, and as a result of that, get the Department of Service involved, the treating physician, the health insurance status, or even the outcome information, so that if someone had a bad outcome, you don't actually reach out to someone who's unhappy with your organization. It's important to note that the minimum necessary standard of HIPAA applies. So if it is not a targeted mailing, then you probably don't need the information about the department or the outcome, and that should not be disclosed. Only the information that's necessary for your particular campaign should be released. Also, it's very important, the notice of privacy practice must state that you will use their PHI for fundraising purposes, or you may not proceed. So those of you who wrote your notices of privacy practices years ago, and since then fundraising has become a more important effort, you need to go check your notice of privacy practice. And then there is also an opt-out option that must be disclosed. So now each communication, each fundraising communication, must include a clear and conspicuous opportunity to elect not to receive further communications, fundraising communications. And the new regulations make it clear that it is any type of communication, including oral communications. So to the extent you're having a telethon or doing some personal solicitation, you must advise the individual that they can opt out and tell them how they can opt out. Once an individual opts out, you may not use their PHI for fundraising communications, and if you do, you will have, in effect, a breach because you have now used it without the authorization. A covered entity may provide information in their opt-out information as to how to opt back in if you'd like. The opt-out method must not cause the individual to bear undue burden or incur more than a nominal cost. The regulations do not give specific opt-out language. The covered entity can write it in any fashion it wants. You can have a single or multiple option method as long as it's reasonable for all individuals wishing to opt out. For example, you can have an email address, toll-free number, or a pre-printed prepaid postcard. The preamble to the regulation explains that HHS believes requiring someone to write a letter and send it to the covered entity is burdensome. So therefore, you can't have as an opt-out method anymore that the individual can write a letter to the organization opting out. But as I said earlier, giving a pre-printed prepaid return postcard is acceptable. The regulations in the preamble also state that an opt-out may be applied on a campaign-specific or an all-fundraising basis as long as you're clear in your notice as to what they are opting out of. Now let's turn to the research rules. The new rules are really an improvement, and they are intended to streamline the informed consent and HIPAA authorizations that are involved in clinical research activities. You were not allowed to have compound authorizations previously, and this allows you to have compound authorizations. There are two types of research activities that you need to be aware of in looking at these rules. There are some research studies, clinical research studies, that require the individual, in order to participate in the study, to authorize the researchers to use their PHI for research purposes. This is what is referred to as conditioned research. If you don't authorize the use of your PHI, you can't be in the clinical protocol for treatment. There's other activities that are more voluntary with respect to the authorization of and the use of PHI. For example, tissue banking or DNA or genes or blood research. Those you can participate in a study even if you don't agree to have your tissues banked. And those are called unconditioned research. Now, the authorization can include both, but the authorization must clearly differentiate between those that are required authorizations to participate in the study and those which are voluntary. And for those where there is an unconditioned research authorization, there must be an opt-out that is provided in the authorization. Another new development is that the authorizations used to only be study-specific. Now, in an attempt to harmonize the HIPAA rules with the common rule for informed consent requirements, as well as regulations of the Office of Human Research and FDA regulations, these authorizations may now authorize the use of PHI for future research. And the authorization may cover PHI collected beyond the time of the original study in the follow-up information or just in your clinical records. The authorization may also designate a class of persons that can be the recipients of the PHI to cover sharing of the PHI in future research. So these have generally greatly broadened the HIPAA authorization requirements for research. With respect to marketing, first a little refresher. Marketing under the HIPAA regulation means any communication about a product or service that encourages a recipient to purchase or use the product or service of the covered entity. And treatment and healthcare operations and case management has generally been accepted from the marketing requirement if it is the services of the covered entity. The change in the rule is that authorizations are now required for all treatment and healthcare operation marketing activities where the covered entity receives remuneration for marketing communications from a third party. So what this means, practically speaking, is that if you are getting remuneration from a third party for any type of communication about healthcare services and products, you most likely will need to get an authorization. So covered entities should scrutinize their relationships with business associates and the remuneration that they're receiving one way or the other from third parties to make sure that they are complying with these rules and fitting into the appropriate exceptions. There are a lot of couponing practices that have developed under the old regs that will need to be re-examined, and we would encourage you to read the preamble and the regulations to have a full understanding of these rules and their new application. Sale of PHI is a new restriction that appeared in HITECH. A covered entity must obtain an authorization for any disclosure of PHI, which is a sale. The authorization must disclose that the sale will result in remuneration to the covered entity. Sale of PHI is now defined in the regs and means a disclosure by a covered entity or business associate where the covered entity or business associate directly or indirectly receives remuneration from or on behalf of the recipient of the PHI in exchange for the PHI. Importantly, this applies not only to where the actual title of the ownership of the PHI is being transferred, but also to agreements that relate to access to PHI or licenses to use or lease agreements where there is direct or indirect remuneration to the covered entity or the business associate. Now, there are numerous exceptions to the definition of sale of PHI. Uses of for public health purposes, so where you are getting, for example, compensation from any government entity for putting together databases for public health activities is an exception to the sale of PHI. Research purposes, again, where there's grants. Treatment. Then we have the exceptions that are already in the definition of healthcare operations for the sale, transfer, merger, or consolidation of a covered entity and the due diligence related to those transactions. But it's important to note that the sale of a covered entity has to be to another entity that will become a covered entity. You can't just sell it to some other organization that won't be a covered entity after the transaction. There's also an existing exception for the sale of accounts receivable to collection agencies as part of the payment exception. We might also add that that organizations that are not single legal entities but have other entities that are under common ownership or control, if those organizations designate themselves as affiliated covered entities, then they can, and the use is otherwise permittable by a single covered entity, then they can engage in certain transactions and it will not be a sale of PHI. There are further exceptions to this definition of sale. As I said, grants and contracts to perform programs or research not considered a sale. Fees that organizations pay for health information exchanges are not considered a sale. And for research uses, you can get remuneration, but it is limited to reasonable cost-based charge. And the regulations and preambles describe what are appropriate indirect costs, and they include labor, material, supplies, as well as related capital and overhead charges, but you may not add a profit margin. So the authorization form, if you need to get one for the sale of PHI, must disclose the form of the remuneration. I'd like now to turn back to Ed Leeds, and we're going to switch to the new GINA amendments to the HIPAA rules.
Thank you, Jean. As the research rules, in fact, indicated, HIPAA is not the only set of rules that protects the privacy of personal medical information. There is, in fact, this statute, the Genetic Information Non-Discrimination Act, which came into being after the HIPAA regulations were implemented, and that protects genetic information. The new HIPAA regulations include provisions that are designed to coordinate with a particular requirement in the GINA rules. And the regulations provide that a health plan may not use or disclose protected health information that is also genetic information for the purpose of underwriting. And this is a strong rule because this rule applies even if an individual provides authorization for the use or disclosure of protected health information for underwriting purposes. There is an exception in the rules for long-term care insurers, but that is it. It's worthwhile to keep in mind that this probably would not be such a significant limitation if genetic information simply included genetic testing and genetic factors in what you might ordinarily associate with genetic information. But the GINA rules include in the definition of genetic information family medical history, and that makes the requirements of GINA and this requirement have a much broader implication. We're now going to turn back to something that is rather core element of HIPAA, and that would be individuals' rights. Individuals have rights with respect to their own protected health information. And I've listed these individual rights on this slide. We've referred to them a little bit earlier in the presentation. We're now going to examine not every one of these rules, but as it turns out, the HITECH Act made changes to the privacy rules, and the new changes that it made to the privacy rules often have an implication for these individual rights. So let's start off by talking about the right that individuals have to request restrictions on the use or disclosure of their own protected health information. They have the right to request it, but in general, covered entities don't need to accept that request. However, under the new rules, if an individual or someone acting on behalf of an individual pays for a healthcare item or service completely out of pocket, then the covered entity has to honor that individual's request not to disclose the protected health information, at least as far as it relates to that item or service, and at least as it pertains to payment or healthcare operations. For example, suppose there's an individual who's being treated for some kind of chemical dependency and doesn't want anyone to know, not even his insurer. Well, he could pay for that expense completely out of pocket and then request his provider not to disclose this information to his insurer. The provider needs to honor that request. Now, some providers may not be set up to distinguish between two different types of information, but this is something that they're going to have to wrestle with and figure out how to code this information or otherwise keep it from being disclosed. It's expected that this requirement will affect only providers, but the rules are actually framed more broadly and could apply to others, at least in a technical sense. Let's move to the individual's right to access his or her own protected health information. This applies to protected health information in a designated record set. I'm not going to go into exactly what a designated record set is, but suffice it to say for these purposes that it generally includes the information that an individual might care about. Now, under the new rules, if an individual requests protected health information in a particular form, and the covered entity can readily produce information in that form, then that's the form that needs to be used. If the covered entity would have trouble producing the protected health information in that form, then there are some fallbacks. If the protected health information is kept electronically and the individual wants to receive it electronically, then the individual and the covered entity should negotiate and agree upon an acceptable electronic form for its delivery. Otherwise, they'll need to seek to agree on another form, and there's always a fallback for the covered entity to produce the information in a readable hard copy. There's another requirement that relates to this access to information, and that is that a covered entity will need to provide the protected health information to an individual's designee as long as the individual makes a very clear designation that the information is supposed to go to this particular person and gives enough information for that to take place. I'd now like to turn to the individual right that people have with regard to obtaining an accounting of disclosures. Now, under HIPAA, as it has existed for the past decade or so, a covered entity is generally required to account for a limited range of disclosures of protected health information when an individual requests. And this range really includes disclosures that are not the everyday kind of disclosures like treatment, payment, healthcare operations. It's really more unusual disclosures than that. So if an individual comes in and requests, asks for when his or her information has been disclosed, the covered entity has to go back 6 years and look up when those disclosures have occurred. The HITECH Act added to this requirement a new requirement that covered entities report a broader range of disclosures, and this could include things as common as treatment, payment, and healthcare operations. If the protected health information is included in an electronic health record, so if an individual comes in and would come in and request protected health information in an electronic health record or to find out when that information has been disclosed, the covered entity would have to go back, in this case only 3 years, to find that information. When the regulations were proposed under the HITECH Act, they extended this requirement to all electronic records in the designated record set. This posed a problem to some covered entities because while an electronic health record may actually be set up to automatically track access in certain disclosures, the designated record set or the routine electronic records weren't necessarily designed to capture that information. The final regulations very expressly say that they do not address this requirement, and they point back to the proposed regulations, but this is something that we are continuing to look for guidance on, and hopefully we will have it in the near future. There's one individual right that doesn't really require the individual's own protected health information, and that is that an individual has a right to receive a notice of privacy practices, of a covered entity's privacy practices, and covered entities have had to produce this. Many covered entities will have produced this, and apart from perhaps some small tinkering, haven't made any changes to this notice of privacy practices for 9 or 10 years. Now there are some new rules coming into play for this notice of privacy practices, and it's time to dust them off and look back at them. There are some new requirements relating to authorization. Authorization is required for and the Notice of Privacy Practices has to say that an authorization is required for most uses and disclosures of psychotherapy notes where applicable. That means if you don't have psychotherapy notes, you don't have to do this. But if you do, you have to say in your Notice of Privacy Practices that authorization will generally be required. You'll also have to say that authorization is required for marketing or for the sale of protected health information. And you have to say that authorization is required for uses and disclosures that are not described in the Notice of Privacy Practices. There are a few other requirements that have come into play for the Notice of Privacy Practices, addressing some of the things that we have talked about today. For example, the Notice of Privacy Practices will have to say that protected health information may be used to contact individuals for fundraising and provide individuals with the opportunity to opt out of those solicitations. They even go, I've listed them here, but they even go to the GINA rules that I just spoke about. There is one rule that has been taken out of the requirements for Notices of Privacy Practices, and that is that they will no longer be required to state that, that protected health information may be used for the provision of appointment reminders and treatment alternatives. Now that we have these changes, and they're going to be regarded as material changes to the Notice of Privacy Practices, covered entities are going to need to think about what they do with their Notices of Privacy Practices and how they go about communicating them. If you are a health plan with a website, then you will be required to post the restatement on the website, or the restatement of the Notice of Privacy Practices, or at least a notice of the material changes that are being made, by the compliance date, which is September 23rd, 2013. And then you'll be required to send out the new Notice of Privacy Practices, or the Notice of Material Changes, with your next annual mailing to plan participants. So if you're a calendar year plan, you would probably include this information with your annual enrollment materials. For a health plan that doesn't have a website, the Notice of Privacy Practices, or the Notice of Material Changes, needs to be distributed within 60 days of the changes when they're made. So if you make them before September 23rd, 2013, right before that, you'll probably have to distribute them by November 21st, 2013. We had thought that that maybe things were moving in the direction of providing this information electronically. However, at least in the comments to the regulations, they have pointed back to the HIPAA regulations that say that you can make this distribution electronically only if individuals provide their affirmative consent. That's rather restrictive and may inhibit many plan sponsors from distributing this notice electronically. For healthcare providers, you're going to have to provide the notice to individuals on request, the revised notice. You'll have to make copies of the restated notice available at any site where services are delivered, and you'll have to post that restated notice in a clear and prominent location at the delivery site. And for new patients, you're going to have to give them the notice and try in good faith to obtain an acknowledgement from them that they have received the notice. That's essentially, those rules actually already exist under HIPAA, and it's really mostly reflecting rules that are already in place. That concludes our discussion of really the substantive changes under the new regulations. I'm now going to turn the mic over to Dee Spagnola, who is going to tell you why you should care about these new rules in her discussion of penalties and enforcement.
Thank you, Ed. So you've heard about the substance of the rules and regulations, and my focus will be on the enforcement process, including investigations, audits, resolutions, and civil money penalties. The Office for Civil Rights enforces the privacy and security rules by investigating complaints, by conducting compliance reviews and audits, and by performing educational outreach to promote compliance. And historically, there has been a strong focus on that educational component. And as I'll discuss, the trend is moving now in the direction of stronger enforcement as opposed to the focus on education. So let's start with a high-level overview of the complaint process. This is the method, or one method of investigating complaints. And basically, the complaint comes into OCR, and OCR personnel will do a preliminary intake and review. And they'll look for 4 basic components before they decide whether or not to move into the investigation phase. First, they'll look to ensure that the violation occurred, or the alleged violation occurred after HIPAA's effective date of April 14th, 2003. And they'll ensure that the entity that is alleged to have violated the rules is actually covered by the privacy rules. And third is a timing element. The complaint has to come in within 180 days of the alleged violation, or within 180 days of when the complainant knew or should have known of the alleged violation. And finally, if taken to be true on its face, the incident described in the complaint needs to rise to the level of an actual violation. The other thing the OCR will do is take a look at it to see if there is any underlying criminal intent. And if that's the case, they will refer the matter to the Department of Justice. We'll take a look at it themselves and either accept it and perform their own investigation, or kick it back to OCR for its investigation. And then once the investigation is completed, there are a number of different scenarios for a resolution, and I'll talk about those in the coming slides. So what exactly is an OCR audit? It's HHS's method of ensuring compliance. And as I said, historically, it's been more of a compliance improvement tool than an investigation. Although the time for education, while not over, is no longer going to be the focus. We saw one signal of this recently, in fact, just last month, where there was the first ever settlement agreement where the breach affected fewer than 500 individuals. Moving forward, I'll go over some of the statistics that further signal the trend away from education and into enforcement. The OCR audit is a comprehensive audit protocol that will assess the processes, controls, and policies relating to the three areas: the privacy rule requirements, security rule requirements, and breach notification rule requirements. And at a very high level, the protocols are essentially a series of questions and inquiries that focus on 2 areas: the existence of formal or informal policies to promote compliance with the underlying rules and regulations, and also an inquiry as to whether or not the policies have been effectively communicated to employees. I've had government investigators say to me that they want to see more than just window dressing. They don't want the policies written and put on a shelf. They want to make sure that these policies are incorporated into the entity's culture on a day-to-day basis. Between November 2011 and December 2012, OCR performed or conducted a pilot phase for their audits. They performed 115 audits through KPMG, who was contracted to actually be on the ground performing those audits. And the audits were selected either at random, with every covered entity or business associate being eligible for an audit, or as the result of a breach report, or in response to a complaint to OCR, that complaint process that I outlined at the outset. And the audit process, like I said, was conducted by KPMG. It commenced with an introductory letter, basically introducing KPMG as the auditor and outlining the process for how the audit would work. And the audit itself, much like many government audits, essentially focused on a few components. So within 30 to 90 days after the date of the introductory letter, the audit itself commences with document requests and an opportunity to respond to those requests for documents. Once that phase is completed, the auditors would then have an opportunity to digest that information, and then the auditors come on site for their actual field work, on-site visits, an entity should expect that process would take 3 to 10 business days. It would involve interviews and meeting with personnel. And then at the conclusion of the on-site visit, the auditors go back, again, now with additional information to digest, and they prepare a draft final report of their findings, which they then send to the entity, and the entity would have 10 days to respond in writing to those findings. At the completion of those 10 days and the submission of the written response, the information is compiled once again, and a final submission is sent to OCR. So whether as the result of a complaint, a reported breach, or an audit, the next phase once the investigation or audit is completed is to talk about a resolution. Most privacy and security rule investigations are concluded through one of 3 means, either through voluntary compliance, through a corrective action plan, or through a resolution agreement. The resolution agreement being reserved for the most serious outcomes, and effectively what that is a contract between HHS and the entity, where the entity agrees to certain obligations, typically agrees to a payment. The contract term is typically for 3 years, and it will involve ongoing reporting obligations and monitoring by reporting obligations by the entity and monitoring obligations by HHS. Now, if OCR feels that the resolution is not satisfactory, in other words, there isn't voluntary compliance, a corrective action program, or there isn't a resolution agreement, OCR may impose civil monetary penalties. And if that occurs, the entity has the right to request a hearing with an HHS administrative law judge to see if the evidence supports the penalties. And speaking of penalties, this is an area where we've seen some change with the new regulations. The civil monetary penalties fall into 4 tiers or 4 categories. And without going into too much detail, they range from, at a minimum, $100 fine per violation to a maximum of $50,000 per violation. And across the tiers, they max out at $1.5 million penalty per type per year. And they are based on a level of culpability ranging from, again, at the low end, where the entity did not know, or by exercising reasonable diligence would not have known of the violation, and to the other end of the extreme, where there's willful neglect, and in addition to that, the entity did not correct the problem. Another area that HHS will look at in terms of determining the civil monetary penalties is looking at the number of individuals affected, record of prior compliance, and the strength of the entity's compliance program. Will all go into the consideration of where you might fall in that range. So, as I mentioned from the outset, we are trending away from a period of education into a period of enforcement. And that's not necessarily new with the latest regulations, but we see that trend over the past several years. Comparing 2012 with 2011, we see an increase in the number of complaints received, up 13%. The number of cases resolved, also up 13%. The number of cases investigated, up about 12%. And corrective action orders are also up significantly. Notably, the only area where we see a decrease in the statistics is where there is a finding of no violation. So again, sort of signaling that increase in enforcement. We also see an increase in the number of entries on what's called the wall of shame. HITECH requires HHS to post a list of breaches of unsecured PHI that affect more than 500 individuals, and those are posted on their website, and it's referred to as the wall of shame. We're also seeing an increase in the number of data breaches, an increase in the average cost of a data breach to the covered entity or the business associate, an increase in investigations by state AG offices, and courts are widening their views of what constitutes data breach in terms of what would qualify for damages. So with all of that, and with a recognition of this trend towards enforcement, I'd like to conclude by looking at what the risk of noncompliance might be. There's potential for loss of contracts, of course, a criminal or civil investigation, which can be expensive in and of itself, can be onerous, and can be very disruptive to the organization. Federal penalties or state fines. And I think one of the most significant risks here is the risk of public harm and reputational risk. Of course, there are legal costs and the costs that could flow from notification requirements. So with all of that in mind, I'm going to turn it back over to Ed, who will who'll talk about the ways to reduce the risk of noncompliance, and he'll summarize some measures that entities can take.
All right, so what does this mean in terms of what you need to do? And maybe it helps to sort of set what your mindset would be going into taking these measures a little bit. I mean, we have new requirements, and the new requirements have a fixed deadline for compliance. We have substantive rules, and we have the enhanced penalties that Dee just spoke about, and certainly the expanded enforcement efforts that Dee just spoke about. They include this audit program, and it's you know, you're always sort of you can be in good shape if you think that you can get through any kind of governmental audit on your HIPAA compliance effort, you know, and really pass with flying colors. That is kind of a gold standard for compliance in some ways. You also want to be thinking about changes in the privacy and security environment. Since HIPAA came into the world, I believe that there are higher expectations for privacy and security than existed before. I think that HIPAA has actually had an effect of increasing sensitivity to these sorts of issues. Meanwhile, you know, on the outside, there's certainly an increased emphasis on cybersecurity. We have heard it referenced in the State of the Union message, and as Amy pointed out, you know, almost every day there is some report about some cybersecurity issue, whether it relates to defense contracting or industrial espionage and things of that nature. Just as I think HIPAA maybe changed the world a little bit and made it more aware of privacy issues, there's no reason to believe that things that are going on in the world might not affect HIPAA. And finally, I think you want to gather your own internal experiences and gather the experiences of others. Your own internal experiences may include little things that have changed in your own organization, changes in technology that you've brought in, or changes in personnel. You know, there's perhaps the possibility that you've named a new privacy official and haven't reflected it in all your documents, or you're going to see something and you're going to say, no, we don't really do things that way, even as it might be reflected in your policies and procedures, or there's a better way that we can do things now that we're looking back at it with all of this experience, and to learn from others' experiences. And you know, there have been certainly many instances in which others have had to report breaches, and where they are reported on government websites, and learn about things like lost flash drives and laptops and things of that nature, and take appropriate measures if you think you need to beef up your measures in that respect. So let's turn to what is really the to-do list that you need to undertake in order to, you know, in order to comply with HIPAA. The first thing that I would put on the to-do list is to assess your security risks and really look at where the gaps are and what you need to do, and look at the security rules for these requirements. Particularly if you're a business associate, you may never have undergone this security risk assessment. These things take time. They take a commitment, a financial commitment, a commitment of personnel. You may need to be gathering personnel who don't always work together. And we are here approaching the end of February, and we have about 8 months before these rules take effect. It is definitely not too soon to be starting your process with this. Covered entities who have already had to undergo the security risk assessment and who are required under the HIPAA security rules to reevaluate and update it from time to time. This is a time to take a really close look at your security compliance efforts and to work with your CISO and others in order to make sure that you're in good compliance. Of course, the efforts that you make can be scaled to your operations based on how large you are, how sophisticated your computer systems are, what kind of protected health information you get, how much protected health information you get. That will have a large role in determining the scale of your operations. But ultimately, these things will lead to security policies and procedures that you will need to have in place, and you'll need to take a very careful look at those as you proceed through the process. For privacy policies and procedures, although the formal requirement applies only to covered entities, there's no question that business associates will need to have their privacy policies and procedures their own privacy policies and procedures in place to address the HIPAA requirements. And you'll need to account for changes in the new rules, the things that we sort of discussed today. And if you undertake fundraising, you'll need to think about that. And if you are coordinating with research activities, you'll need to think about those things. The thing that I think I'd like to highlight for this are really the new breach rules. Having breach rules in place, ready to go, is very, very important. You don't want to start thinking about what your rules are going to be after you've had a breach. So you'll need to think about those. You'll need to think about your coordination between covered entities and business associates. You'll need to have procedures in your internal policies and procedures that address those things. Anytime there are changes of this nature, you have to start thinking about training, informing the people who work with protected health information about what the new rules are and how you're going to respond to them. And that's a requirement for both business associates and covered entities. The notice of privacy practices is really something that is unique to covered entities, but as I said, this is something that you may not have looked at for a very long time. It really is time to look at it in terms of whether there's any information that you need to change on it, as well as the specific legal requirements that now have to be met under the new HIPAA rules. In terms of your business associate agreements, yes, you may have been given an extra year, but many covered entities and business associates have already started to enter into new agreements. You might be having new agreements and new vendors for your program, and so you should be thinking about what those business associate agreements will say, what it is that you're going to put into your business associate agreements to comply with the rules, and other factors that you're going to take into account in preparing those agreements. Business associates, you are really right in the middle of this, because you're not only going to be negotiating business associate agreements with covered entities, but you may be negotiating business associate agreements with your subcontractors as well. And you'll have to think about the effect of these rules on your other HIPAA compliance efforts, other HIPAA documents, and HIPAA practices. Although these rules are sometimes called the Omnibus rules, there are certain items that bear watching for the future. Certainly those accounting of disclosure rules, which they specifically reserve judgment on in terms of the final regulations. We should be watching for those. I would hope that maybe there will be some relaxation of the electronic distribution rules for notices of privacy practices. I know health plans would like that. The HITECH Act suggested that there would be changes in minimum necessary rules or guidance on the minimum necessary rules. We have not yet received that guidance, and so the sort of rules that have been established under the HITECH Act itself remain in effect. The HITECH Act also pointed that we might be getting guidance on technical safeguards that might come out on an annual basis. We haven't really been seeing that, but maybe that will be forthcoming now that these final rules are in place. And always worth looking for further information about governmental activities and the penalties that they're assessing and what their enforcement activities are.
So that concludes our prepared remarks for this program, and Ballard's HIPAA team is ready to help you assess the impact of these final rules on your current HIPAA compliance programs. Over the last 10+ years, we have worked on many HIPAA projects ranging from implementation to breach investigations, and we'd love to work with you. We'd be happy to discuss forms and policy reviews, updates, and training. We're prepared to discuss project fees and other arrangements that work for you. We will have time to take a few questions until for the next 6 minutes or so, but for those of you who are perhaps signing off, I'd like to remind you to do the evaluation and survey that you will be sent. It's very helpful for us in perfecting our programs and in also knowing what you want as far as future programs. So going to questions, we've received quite a few here, but we'll take a few. I guess I'll take one that I think is pretty quick and that came in towards the end, but is probably on everybody's mind. That is there a private right of action against a covered entity or a business associate under the statute? And the answer is there is not a private right of action by individuals. However, HITECH did add 2 areas where individuals could recover. One is that the HHS is to put out regulations that establish a methodology for the distribution of certain civil monetary penalties in certain cases, and also HITECH added a provision that state attorney generals can enforce the HIPAA rules, and if they do, the state attorney generals can recover damages on behalf of individual residents of their state in amounts that need to be determined. So there's no direct cause of action, but there are ways for individuals to get some recovery through government entities. Another question I'm going to turn to Ed Leeds for, and that relates to the second question. What is your advice when employees regularly share their PHI in various forms, verbal, electronic, etc., with their HR staff with the hopes they will assist them in claims issue or a medical coverage issue?
And this question really has been an issue for employers for quite a while. And let me start off by saying that if this happens, you haven't violated HIPAA. Employees may come to you all the time with problems and tell you, their complete medical history before you can stop them. But there are things that you should consider when this comes up. And it's sort of what is the culture of your workplace and what is the culture of confidentiality that you're trying to create about this kind of information that's going to be at play here. Certainly you can hear the employee out, take the information. You can put the employee in contact with your administrator or the insurance carrier. You can try to do that in a friendly way. You could even reach out to the plan administrator or the insurer yourself and say, get back to the employee about this, don't tell me any information. At that point, you haven't gotten any protected health information from a covered entity. The issue arises when you start to get that protected health information from the covered entity. And if you think that you need to be involved in that and getting that information, again, there are a number of ways to handle it, but you're going to need to make a choice whether you're acting as the caring employer taking care of the employee. In that case, as an employer, you're not really entitled to the information, and you should get an individual authorization in order to be able to get the information from the health plan to help the employee. Or are you going to be acting more as a plan administrator, in which case you would amend your plan document that would allow you to have that information in that way. and then proceed on that basis. Or you could even potentially have a business associate agreement helping the insurer to deal with its issues with the employees, but that's a little bit sort of beyond the typical pale of things. It really depends on how you want to handle it, how administratively you can handle it, how your culture deals with this kind of situation. But whatever you do, it's something that should be reflected in your internal policies and procedures, how you proceed with this, and you should act in accordance with those rules.
Thank you, Ed. We're going to take one final question, and that is the following. Is a lender in a typical secured credit facility to a covered entity required to abide by the business associate rules? In other words, is that lender a business associate? And the answer is no, because a business associate is an entity that is performing a function for the covered entity. In this case, the lender is performing its own function. But my question is why would a lender in a typical secured credit facility be getting PHI? Because really the minimum necessary standard applies. While this is a healthcare operation of the covered entity to get this credit facility, there is no reason really why the secured lender would need access to identifiable information. You could give them de-identified information and therefore avoid any HIPAA risks. So I think it's really important to understand sort of what your role is when you're dealing with a covered entity and what the rules are that apply. And at that, I think we must adjourn, and we appreciate your participation, and thank you very much.
Yeah, he was right.